Next, from Chicago at the Illinois Bar Association meeting, we hear a panel of judges and legal experts discuss how social media, such as texting and tweeting by jurors and those in the courtroom, are impacting the operation of the courts. This runs about 1 hour.
I'm going to talk about two areas of social media today impacting jury trials. One, more briefly, the use of social media in the jury selection process. And then I'm going to talk about in more depth the concerns we have with jurors using social media and what we should be doing as judges and lawyers to try to prevent mistrials and try to ensure a fair trial. The topic of lawyers using Facebook and other social media to investigate the veneer during jury selection is a fairly new topic. There's not a lot of information on it out there. In federal court, it's harder to do this because in order to conduct social media research on a jury panel, you have to know the jurors' names in advance, or if you find them out the morning of, you have to have internet to be able to do it. Well, in the federal courtrooms, we don't have internet access, or the lawyers don't have internet access unless they get court permission to do so. And they typically, unless we get a special panel, do not have jurors' names or potential jurors' names in advance. I know in state court, I think it's a little bit different, that they often do have the potential jurors' names in advance. So if there are no limits on it, when they do get those names, they can go out there and look at social media to try to find out what they can about the potential panel. Why would they want to do this? Well, research shows that people are more candid online than they are in court. And wouldn't you want to look at somebody's Facebook and see what they're saying, see who their friends are, see what their affiliations are, information that they might not be comfortable talking about in court, or information that you might not ask the right question to elicit in court. The only legal entity that I could find that has addressed whether or not this is appropriate is an opinion from the New York Law Advisory. And they concluded that an attorney may research potential or sitting jurors using social media services or websites, provided that a communication with the juror does not occur. And communication is defined very, very broadly. Any indirect or direct communication. They also say that the attorney should not engage in any kind of deception or misrepresentation, such as using third parties to contact someone on a Facebook. So befriending somebody on a Facebook who is friends with a potential juror in order to try to get information would be improper according to the New York Law Advisory opinion. And common sense should tell us that as well. So should we let lawyers use social media to investigate potential jurors? That's a question for us as judges. Are they overstepping bounds if they're looking into jurors' Facebooks and other social media sites? If they're looking at tweets, do we tell jurors in advance that the lawyers might be looking at their Facebooks or other social media? This raises privacy concerns. But on the other hand, our goal is to end up with a fair jury. And if we want to know about jurors, the social media site is a great place to get information for those who use it. My personal opinion is looking at the social media is fair game as long as ethical boundaries are not crossed and privacy concerns are not violated. But I think if it's something we are going to let jurors do, that it should be addressed with the lawyers in advance so both sides know that it's fair game and both sides have the opportunity to look into it if it's something they want to do. One final note for the lawyers who are in here, who have websites and Facebooks of your own. You might take a look at those and say, is this something I would want a juror looking at? What's on here that's publicized about me? Is this something a jury should see? Or is there something on here I might not want a juror to look at? I want to talk more in depth now about impaneling a fair jury with the social media reality that we live in. Social media presents various problems for judges and for lawyers trying cases. We don't want a jury to do any kind of independent research about the case. We don't want them to communicate about the case, and we don't want them somebody improperly contacting them about the case. These are not new issues. For anyone who has tried a case, these come up in every trial, but they're different now because of the age of technology that we live in. It's so easy for jurors to access the internet. It's so easy for them to access social media that this information is at their fingertips. And it's very, very hard for us to monitor. A couple years ago, an article deemed this the Google trial. There were so many mistrials occurring, or so many issues being raised from improper social media use by jurors. Someone titled this the Google trial, which is what we all want to avoid. I want to give you some examples now of cases that have had problems with social media to show you why I think we need to be proactive in this area to prevent this. I had a conversation with a judge on the East Coast about a year ago, and she said, well, I don't think we need to say anything about social media because if we talk about it with the jury panel, we're just going to give them the idea that it's something they can do. And I respectfully disagree with that because everybody uses this now. It is out there. And here are some real cases to show you why there's a concern. And I apologize, my slides aren't working too well with the lights in here. The Supreme Court of Kentucky recently issued an opinion in a very high-profile murder case of a minor, where after the verdict came in, they discovered that there were two jurors who were friends on Facebook with the minor victim's mother, which raises the question of friends. And the court held that friendships on Facebook and other similar social networking websites do not necessarily carry the same weight as true friendships or relationships in the community, which are generally the concern of voir dire. Nevertheless, the court sent it back to the trial court to conduct a further hearing to find out, one, if one of the jurors had lied about not being on Facebook, and two, whether the jurors were tainted in any way by finding postings on the minor victim's mother's Facebook about the trial and about the events that were on trial. Another recent case, the former Attorney General in Kansas was at a disciplinary hearing before the Kansas Supreme Court recently. And during the hearing, a clerk for the Kansas Court of Appeals was tweeting about the hearing and tweeting about the Attorney General. One of her tweets was, "Why is Phil Klein, who was the Attorney General, smiling? There is nothing to smile about, douchebag." And she had some other similar kind remarks about the former Attorney General. That clerk's conduct is now being investigated. A federal judge in Florida about 2 years ago postponed a resentencing of a defendant who was serving a 10-year term for drug charges because a juror from that defendant's trial was quoted in the Miami New York Times as saying she had done independent research on the case. In the United Kingdom, where they might be a little more strict on this than I've seen in the United States, a juror was recently sentenced to 8 months in prison for contempt of court after contacting a defendant facing drug charges via Facebook. In Florida also, a mistrial was declared after a federal judge learned that 8 jurors had researched a drug case on the internet. They were looking up certain terms that they had heard during the course of the trial, and they were investigating the defendants. In Baltimore, there was a mistrial where jurors were communicating via Facebook with each other during a deliberation period, and one of them received an outside online opinion about what the verdict should be in that high-profile case. This was during the course of the trial. Mistrial in another case where a bailiff found printouts of Wikipedia explanations of scientific terms in a criminal case. For those of you who don't know what Wikipedia is, sounds like you may all know, but go to wikipedia.com and you can get information on almost anything you would want to know. Whether it's accurate or not is another question. Here's another one of my favorites. In a civil trial, during the course of the trial, one of the jurors tweeted, quote, "Oh, and nobody buys STOM, S-T-O-M, which was the name of the defendant building materials company that was on trial in the civil case. It's Mojo, question mark, and they'll probably cease to exist now that their wallet is 12M for 12 million lighter." They came back with a $12 million verdict shortly after that against the company. But this tweet was sent before the verdict. In Massachusetts, in a rape case, a juror sent an email during the prosecutor's argument, quote, "Just say he's guilty and let's get on with our lives." A witness during a Miami trial was discovered while he was on the stand and the judge and the lawyers went to a sidebar to address an issue. He had his smartphone up on the stand and started texting his boss about his testimony. It is the only federal appellate court case, it's a Third Circuit case that I have found dealing with this issue. It was a high-profile federal corruption trial in Pennsylvania, and one of the jurors kept posting the progress of deliberations on his Facebook. On September 18th, during the trial, he posted that he was glad they got a 5-week reprieve. There was a recess for a long period of time for a health issue. On January 11th, after the trial resumed, the juror was wondering if this could be the week to end part 1. January 12th, juror was wondering if today will really be the end of part 1. Obviously it wasn't. March 4th, juror can't believe tomorrow may actually be the end, exclamation point, exclamation point, exclamation point. And then a friend responded to the March 4th Facebook posting by asking, "Of what?" And the juror said, "Can't say till tomorrow, LOL. On March 8th, 4 days later, juror is not sure about tomorrow. A friend responded to the March 8th Facebook post by asking why. And the juror said, "Think of the last 5 months, dear." March 9th, the juror said, "Today was much better than expected, and tomorrow looks promising too." And then on March 13th, stay tuned for the big announcement on Monday, everybody. The verdict is coming. So the Third Circuit found that there was no abuse of discretion in the trial court's refusal to grant a new trial, essentially because the Facebook postings were innocuous and there wasn't any prejudice from them. Another one of my favorite ones, this will show what a small world it is in the world of technology that we live in. A juror in a medical malpractice case, after the trial, fortunately, was sent a match by an online dating site. And when she read the profile of the potential date, it turned out to be that he was the medical expert from the trial where she had just sat as the juror. What the article didn't tell us is if she went out on the date or not. So technology is here to stay. If any of you have teenagers, you know that, and they don't even have to be teenagers, my 10-year-old is this way. These kids communicate via texting. They communicate through their smartphones. I was on the plane, I was in DC last week, and me flying back, and there was a young mother with 2 kids next to me. One was probably about 2, and the other one around 4 or 5. They both had iPads. The kids, not the mother, they both had iPads. The generations coming up, this is the world that we face, and it's here to stay. I just had a jury trial earlier this week, and I now ask my veneer during questioning, do you own a Facebook? Do you actively use it? 21 out of the 24 veneer members had Facebooks, and these were not just jurors, 21 and younger. So it's here to stay. So we need to be proactive to prevent these Google mistrials and to preserve the integrity of the jury system. How do we do that? I'm going to touch on 3 surveys regarding social media that have taken place. One by the Federal Judicial Center, a very recent one by the Executive Session for State Court Leaders in the 21st Century, and an informal one that I have done over the past 2 years. In October of 2001, the Federal Judicial Center sent out a questionnaire to all active and senior judges to determine, are we having problems with social media, and are you actively taking steps to try to prevent problems? More than 500 judges responded, and according to the Federal Judicial Center's findings, most judges have taken steps to ensure that jurors do not use social media in the courtroom. A couple of examples. Approximately 30 judges, or 6%, detected the use of social media during trials. Everything from friending through revealing, identifying information about other jurors in their social media. Only 6% of the respondents, or 30 federal judges, reported that they have not specifically addressed jurors' use of social media. Most judges who have addressed it are doing it through jury instructions. The Executive Session for State Court Leaders in the 20th Century recently published some findings that they had from research they've done in 30 civil and non-capital criminal cases. 9 trial judges in 7 states participated in this survey. And ultimately, 6 criminal trials and 7 civil trials were polled. Prospective jurors from the veneer were also included in this. And the jurors were instructed not to use the internet. Their results found that 87% of prospective jurors said that using the internet to communicate with friends or family or to post information about the trial would violate the judge's instructions. Good to know that they feel that way after being instructed. 86% said that they could refrain from all such social media use, and 14% said they would not be able to, even though the judge told them not to do it. On a prospective jurors, 44% said they would have liked to use the internet to obtain information about legal terms, about the case. 23% said about the parties involved. 20% said about the lawyers. 19% said about the judge. 18% about the witnesses, and 7% about their fellow jurors. Over the past 2 years, I've been doing an informal survey. After every jury trial I give questionnaires to my jury. Anonymous questionnaires, I ask them to complete them. I leave the room, I tell them I am not going to associate this with the trial. The lawyers aren't going to see these. I know it's not a perfect study. As I said in my article that you have, I'm quite sure I would get a Daubert or a Fry challenge on it. But it was to gather data. And Judge Kennelly participated with me for about a year on this. Covers civil trials and criminal trials. And I asked the jurors, were you tempted to communicate about the case through any social networks, such as Facebook, LinkedIn, YouTube, or Twitter? And if so, what prevented you from doing so? At the time I did these slides, I had about 227. I have some additional ones now. Only 9 jurors reported any temptation to communicate about the case through social media. And each of the jurors said that ultimately he or she did not succumb to doing so. Out of these 9 jurors, 8 of them gave reasons why. Wanted to keep an open mind. The judge, direct orders. I morally thought I should obey the judge. I swore not to. Didn't want to get, and then I can't read the rest. My oath not to tell. I took this very seriously and wanted to do what I swore I would. Out of the other surveys where they said they were not tempted to, here are some responses, and there are several themes that have emerged that I think are helpful to judges in deciding what we should do to be proactive, what we should do in going forward. Some of the jurors just said no. Well, absolutely not. I was not tempted to. One, in all caps, not at all. One theme that came through loud and clear was the importance of instructing jurors that they cannot use social media. I think this is critical because given the age of technology we live in, everybody is used to getting instant information. They're used to, if they don't know an answer to something, they Google it, or they go to Wikipedia, or they use one of the other search engines. They don't necessarily know that they cannot do that during trials. So it's essential for us to tell them. Comments that I got, and these are quotes from the questionnaires. The judge's instructions, the judge, your instructions, the law, because the judge instructed us, was instructed not to, ordered not to look, the fact that we were not supposed to, stay true to the orders. And my time is almost up here, but there are similar comments that I got about the instructions, and I repeatedly instruct my jury. I tell them during voir dire, I tell them once they're impaneled, and I typically tell them at the end of every day, especially in trials like I just finished, the bartender trial. I just completed that a couple weeks ago against the city of Chicago with all of the media attention and all of the focus on that case. I told my jurors every day, do not do this, do not do this. Just a reminder. Another theme that I saw in the questionnaires is a sense of fairness. It wouldn't be fair, morally. Don't want to sway my opinion. I don't want to compromise the case. I didn't feel it was right. Also, a sense of personal pride came through. I was proud of the fact that we as a jury did not discuss the case until it came time for deliberations. Made me feel like I am doing something good. Feeling of citizenship for participation. Great American experience and privilege. The item I saw was some people just don't use technology. So for me, these instructions or these questionnaires were instructive as to what we can be doing to be proactive. During voir dire, ask jurors about their social media use. See who uses social media, and you'll get a sense. Some of them, you can almost see them start twitching when you tell them they won't be able to look up anything about the case. Instruct them repeatedly, and tell them why. I have here the CACM, the Court Administration and Case Management instructions. I'm not going to read them. I think they're in your materials. CACM modified its instructions about a year ago to add this element of explaining why to the jurors they can't use their social media. Because again, they may not understand. They're used to going to technology, they're used to getting instant information, and it's up to judges to tell them, you can't do this, and this is why. One final note, the American College of Trial Lawyers has proposed that jurors sign a pledge that they won't do any independent research. I have not tried that yet. I would prefer not to go down that route if we don't have to. But I do think we need to be proactive to keep jurors from going to all of these sites. Sorry.
In any event, I have a question that I'm going to put to Judge Burns just as an initial question, and I don't want to put you on the spot, but there is a new order that Chief Judge Evans issued lately that addresses the issue of the use of cell phones and tablets in the courthouses, and in particular the criminal courthouses. And I'm not going to ask you to comment on whether it's a good idea or a bad idea, but what I'd like you to comment on, if you would, is do you have any personal experiences or anecdotal experiences that you're aware of that have led to the issuance of this order? I mean, is it an epidemic, or is it things that are just evolving and we're trying to nip it in the bud?
Just this week, Judge Evans issued an order banning all cell phones from 2060 California and suburban districts. And it's my understanding the reason behind that is because of improper, not necessarily social media contact, but because they were concerned that people were taking pictures of witnesses and also jurors and sending them to other people. The good news is there's a lot of exclusions here. The judges are excluded, the lawyers are excluded, the media is excluded, government officials are excluded. But there was concerns, and there were several cases in 2016 California where people were actually standing up in the courtrooms, and some of the courtrooms are very small. in taking photographs during a particular trial. The sheriffs would grab the phones and either the pictures were deleted or not deleted, and there's a lot of concerns on how it's going to be implemented now, but it's something that probably needs to be done because of the fact that there is this concern, and there's a concern here, obviously, for witnesses coming forward, there's a concern for victims, and obviously there's a concern that jurors have if they think that they are going to be broadcast.
Okay, thank you very much. Let me read the first question, and it is this. New Illinois legislation prohibits employers from asking for the Facebook passwords of people seeking employment. Does this new law also apply to judges? Do judges ask law students for their Facebook passwords before extending offers of employment? Judge St. Eve, maybe you can address this issue because I know you do hire law students. Maybe Judge McWilliams does as well, so maybe both of you can tackle this issue.
Well, first of all, I don't have a Facebook, full disclosure. And my law clerks, I do not ask for their passwords. But we do have a social media policy at the federal courthouse that makes clear what they can and can't do in terms of postings about where they work and what they do. Chief Judge Holderman put this in place about 3 years ago, and they're not allowed to put anything on their Facebooks about where they work or what they do. But I don't monitor that.
My answer is exactly the same. I have a policy for my own courtroom and my own staff, but it is that they don't post and I don't require their passwords.
Okay. This is according to Judge St. Eve's article at page 20. The American College of Trial Lawyers has proposed a statement of compliance that jurors will not conduct independent research into issues or parties involved in the trial. What are Judge St. Eve's view on the ethics of judges independently researching factual issues on the internet in deciding pending motions?
I know why you're asking me that question. Given recent comments by another judge, I don't do it. I rest on what's before me. I rest on the papers. I certainly don't do it. I will tell you, though, that there are times that new lawyers come into my courtroom who I don't know and I'm not familiar with. I will Google lawyers and see who they are. I've done that frequently. So check the website.
Bob, I have a question for you. If you're an attorney at a jury trial and you have the luxury of conducting an investigation into the veneer, whether it be through Facebook or Google or what have you, and you discover that a juror has been untruthful in answering the questions during voir dire, what ethical obligations do you have as an attorney to bring those issues either to your opposing counsel or to the court's attention before the trial moves on to the next step?
I don't think there's any doubt that you call the matter to the attention of the judge immediately. And that would obviously implicate getting opposing counsel involved as well, Pat. That sort of thing has come up in cases. The time to deal with it is immediately, and whether or not it will result in mistrial or result in sanctions to the juror, that's up to the judicial officer, it seems to me.
Has anyone had that experience?
I have not had that experience with social media. I've had that experience with criminal background checks, where I've had background checks done and a potential juror is not candid about his or her background check, and then I confront the juror. There is a case pending where a court is trying to decide on the issue of social media research, whether or not one of the parties knew about a potential juror's lying to the court from that party's own research on the juror. And the fact that the party may not have brought it to the court's attention, the court has said you have no basis to come in and complain now over this that goes along with what Bob said. If you find out about it, the time to tell is right away. Bring it to the court's attention, bring it to your opposing counsel's attention. And if you don't do it, you're not going to be able to come back in later and complain about it if you knew about it.
I've got a comment. Oh, I was just going to say, in my courtroom, I know it takes almost always for the 1 and 2 and 3 week trials a full day to pick a jury, and the attorneys in the state court do get copies of the jury cards by and large. And they do tell me more often than not, they have an assistant going back to their offices and checking on all of the jurors. And again, as long as there's no violations of privacy or ethics, I certainly allow it, and I think perhaps many lawyers have an allegiance to their clients to do so.
Why don't you pass that down to Chuck, because I have a criminal question. Maybe he can address this.
Yeah.
The question is this. Prosecutor posted a derogatory comment about my client during jury trial on Facebook. Hopefully this isn't a real issue, but jury already sworn in, instructed not to use internet for the case. Should the court order a mistrial absent evidence of juror receipt of communication?
Well, the bottom line is, what's the harm here? Is this are these 12 impaneled jurors that have been instructed not to look at the internet, not to look at Facebook? How are they going to be affected by this? Now, whether or not he's got some ARDC problems is a whole different issue. However, I don't think it's going to affect the trial. I would not declare a mistrial on that. I guess I'd probably, to be safe, I would conduct an individual questioning of all the jurors to make sure that they haven't heard or seen anything of it, if it was requested. But again, it's kind of like, is there a pink elephant in the room if you address it? But I would not grant a mistrial just based on those facts alone.
Bob, if you can address the ethical implications for the prosecutor.
Well, it strikes me as obviously inappropriate, but, you know, as we sit here and talk about this, I wonder if we're not being a little naive if we think, and I respect Judge St. Eve's research after the fact in terms of jurors complying with their mandates, and maybe juries in federal district court adhere more closely to the admonishments of the judge. But I think it is a little naive to think that jurors don't discuss these issues, that jurors don't independently investigate matters. For example, as recently as last Friday, I was told, incident to a CLE program we were conducting at the Chicago Bar Association, of a circumstance where a juror, during the course of the trial, conducted research to impeach the prosecution's theory of the case, shared that information with fellow jurors, resulting in an acquittal. There are other cases where jurors have, in one circumstance, again, this past week I was advised of this situation, a juror, during the course of the trial, went to the scene of the incident to check out whether the lighting in the vestibule of the building was as dim as was suggested by the defense, such that the identification was put in question. When the juror arrived at the vestibule, she found that the vestibule was fully lit, very easy to identify folks in her mind, and that information was conveyed to fellow jurors. This sort of thing happens, and just one final point. I raised the question whether or not as a disincentive to jurors violating their obligation not to discuss the case. Keep in mind, you put a jury in the box, and whether it's a high-profile case, whether it's a civil or criminal case, this is the most important thing those individuals are doing at a particular time. It's their natural instinct to want to talk about it. So why not, like some judges are doing, why not let jurors talk about the case prior to final deliberations, as long as they commit to only discuss the evidence among all of them, with all of them present, and commit not to form a final opinion until all the evidence is in. There's a study that was done in Arizona where some almost 100 jurors in each instance, some who were instructed not to discuss the case, others who were allowed to discuss the evidence as it came in. The results of the analysis were essentially the same. People did reserve making a final judgment until the end of the day. So I'm not sure that answers the question, Pat, but gives me a chance to shoot up my mouth.
And I have to defend myself for a minute. I'm not saying that instructing juries will guarantee that a juror doesn't go and look. There's always that risk. What I'm saying is we need to be proactive and instruct because there is a presumption that jurors will follow our instructions. And I truly believe that the majority of them do, but there's always the risk that somebody is not going to. But if you don't instruct, then that risk goes up a lot higher because we have to educate them.
We have a question on the floor.
Yes, Al Durkin from Chicago. I had a follow-up question. I don't remember if it was Judge St. Eve or Judge McWilliams, but I want to tell you, I think this is an excellent program, especially for a white hair like me. I got my first smartphone last week. Now, if that's not an oxymoron, nothing is. But my kids have been doing that for years. But one of you said something about if you determine during the course of voir dire that a prospective juror had, we won't say lied, but maybe not been as truthful as one would like, and that you had an obligation ethically to bring that to the court's attention, if not to the opposing counsel, and then the court will bring the opposing counsel's question. Here's my question. Ethically, voir dire a juror, we've got the cards like Judge McWilliams said, you find out that that juror's mother had a medical malpractice case 2 years before, whatever, they didn't say that they were ever in court before. That might be something that would be helpful to my client. How do you weigh the ethics of bringing that information to the court's attention and invading the attorney-client privilege or the obligation you have to your client? How does that get weighed in those set of circumstances? Do you withdraw from the case then after 4 years and $150,000 of expense or mistrust? Yeah. What happens in that? I understand the ethics of telling the judge, but there's an ethical obligation you have to your client too. And as they say on the radio, sit down and wait for my answer. Thank you.
You want to talk about that? Bob's going to. Yeah.
I don't think there's an issue of attorney-client privilege, and unless I misunderstood your question. There's a point at which, if our system of justice is to function effectively, lawyers have an obligation to the court that sometimes is apparently in conflict with the view that we conduct ourselves as zealous advocates. But in the circumstance that you provided, I don't think it's a violation of privilege. There are circumstances where that could arise, but in that context, it doesn't. I don't see that you're violating your obligation when you convey that information to the judge and deal with it directly. Because I always think about what's the worst case scenario. And the worst case scenario is that sometime during the course of that trial or shortly thereafter, that failure to disclose or misinformation will be revealed. There'll be an investigation by the court. The juror will be brought before the judge. And your role and your knowledge of that circumstance and not having revealed it is probably going to be more problematic than you have to discuss the matter with the client in the first place.
If I could just take that. Yeah, there's a recent case that came out by the Illinois Appellate Court First District, and it's called McGee versus the City of Chicago. And I believe that rightfully so, the appellate court is scrutinizing these cases. And they're saying, it's not maybe not even the prejudicial effect, it's the potential for the prejudicial effect. And the judges are required to look into this, do not underestimate anything, and voir dire the jurors if something comes to their attention, and be very proactive if there's any involvement with potential, jurors getting extrinsic information. So, Justice Tice. Morning.
Justice Tice, perfect timing because you have a question, but there's a question that maybe you can address, maybe you can't, but I'll leave it to you. And this is a question from the floor, so your timing is impeccable. The question is, do you believe the Supreme Court should set out in the Supreme Court rules, or should set out in the Supreme Court rules on social media for judges and attorneys? I don't know if that's something you care to address. I don't want to put you on the spot. Maybe it's something you can't address.
Let me first say this. My name is Mary Jane Tyson. I'm from Chicago, and specifically I wanted to engage Professor Jones. Good to see you again, Professor Jones. I admire your research into judicial ethics and social media, and I have, like many others, followed your advice that there are so many issues of concern for judges that the best answer is not to be engaged in social media at all. But what that means is that we are, by definition, isolated from 1 billion other people. We don't have our own experience of social media and its use, which concerns me in terms of the fact that we will be asked to make decisions about what is prejudicial, what is not. If we don't even know how to turn it on, it's pretty hard for us to have a very sophisticated understanding of the use of it. So my question to you specifically is, let me say this too. I can't tell you how often people come up to me and say, gee, your grandchildren are cute, and I say, I don't know what you're talking about. And they say, well, I saw the pictures on your son and daughter's Facebook page, and I want to know, how do I get to see the pictures of my grandchildren on their Facebook page when you've told me I shouldn't have a Facebook page? So my larger question is this. My larger question about this is, can you give some advice to judges so that we can engage in this discussion that it's not the future, it's today as we understand it, it's revolutionary. My own sense is we need to know more about how social media works so that we can make these kind of decisions. Can you help us find the best way to engage with social media in an ethical manner? And largely, I think all of us are struggling through these issues, and I know the court is as well.
Thank you, Justice Tyson. That's tough, the grandchildren, that was tough. But I think it's important for judicial officers and judges to recognize that they are in a very different position than lay people, than attorneys, than an average citizen walking down the street. So I want to answer your question by, one, talking about my philosophy with respect to the judicial office, and then for the judges who really want to use social media, what might be some of the ways they might approach it without running afoul of the ethical requirements. And I'll try to be short, because I know we're running very short on time. But one of the things that I think is very important to understand is that more than any other country, we are a nation of laws. And that in order for, what prevents the average citizen from taking the laws into their own hands is the fact that they can file a document, go into a court, and have their most important conflicts resolved by a person they believe to be impartial. If we lose the ability for citizens to lose, if citizens lose confidence in the judiciary, then the result is anarchy. Citizens have to feel confident that they have the opportunity to go have their arguments heard without somebody who is independent and impartial. And the power and the prestige associated with the judicial office is, in my opinion, the most important position that you can have in a country like this in a nation of laws. So when you wear the black robe, you always have the black robe on, 24 hours a day, 7 days a week, whether you're in the chambers or not. It is just the position that you hold, and it is not subject to compromise. So because of that privilege and that responsibility that you have, it is incumbent upon you to give some things up. Now, am I saying that you have to give up watching the grandkids on Facebook? No. But you do give a lot of things up because it is paramount that the public maintain that confidence in the office that you hold. Now, what some of the judges have found success with is setting up pages where they, first of all, do not identify themselves as a judge in any kind of way. Another thing that judges have done, particularly the judges who have used Facebook and social media for political campaigning, is they have set up political campaign pages where the judge himself is removed from the page, but a committee actually runs the page. Okay, so the judge has no personal link to the page. All right, but another thing that judges do is not only remove their identity from, when I say identity, I mean the fact that they are a judge, but what some judges do is they have very close family members who have these pages up, and they have access to the page, all right? And so there are or their spouses or relatives. And one of the things that I think is important to understand is that I don't necessarily advocate an absolute prohibition on use of social media, but more so situations where you are befriending and establishing relationships with people on social media that might give the impression that you have a special relationship with this person. And I will say just one thing in closing, that one of the big questions right now in Illinois and around the country is, well, why should we treat these social media relationships any different than, social media friendships any different than we treat friendships in everyday life, face-to-face friendships. And one of the reasons why I have heard, my response has always been, I should say, is that when I am on the golf course with someone and I'm talking A to B, those communications are not subject to the public, and the public has no idea what we're talking about. The social media friendships and relationships and communications are conveyed to the public. And whenever that's conveyed to the public, whenever that friendship is conveyed to the public, there is that risk of losing public confidence. And it's just a risk that we cannot take. We have to have our judges separate and apart to some degree. But again, removing, I would say buffering yourself, your office, and your identity from the social media website is probably the best way to go, to have spouses or relatives like that you have access to. And removing any kind of identification of you as a judge from your email and so forth, I think is probably the best way to go. And I continue to feel bad that any advice I gave might have prevented you from seeing your grandkids.
I'd like to thank you. We've run out of time. In fact,
You're watching the Illinois Channel, an independent nonprofit corporation formed to provide gavel-to-gavel coverage of Illinois state government and other public affairs events taking place across Illinois.